Gang, what's up? Aaron here, Canadian Loney. Sorry for the delay in getting started. We'll be rocking it out for the rest of this video. Let's get right into it. Jody Wilson Raybould is back in the headlines. Trudeau is not going to easily escape this scandal. Let's take a look. Maybe he's going to jail. Maybe they all are. They should. That's a nice thought, right? Let's take a peek.
I mean, just to stand by and watch the SS Trudeau, sink on its own.
All the legacy media, all that propaganda, they've got the radio stations, newspapers. Like, I don't know how a proper Canadian is supposed to keep their head about it. Anyhow, what is going to bring them down? It might be an old scandal. Let's take a look.
God damn it, that's
we'll
not
get
news.
into the phone
us?
call, like actually the audio from that phone call at the end of this. But in the meantime, we've got this story to tell. Like, I wasn't paying attention back then. I heard about this, but I didn't really follow it. I kind of know what happened now. Let's take a look.
It was back in February 2019 at a parliamentary committee that Jody Wilson Raybould famously spoke her truth on how Trudeau pressured her when she was Attorney General to withdraw criminal charges against mining company SNC-Lavalin. Fast forward to earlier this year, when Democracy Watch sent a letter to Ontario Attorney General Doug Downey, asking him to pave the way for a private prosecution of Trudeau for obstruction of justice and breach of trust in the SNC-Lavalin affair. But the Ontario Attorney General's office decided to stay the proceedings, stating the unlikelihood of conviction. Yet Democracy Watch's Duff Conacher says there is more than enough evidence to proceed and has asked the Ontario Attorney General to reconsider in a new letter.
And there's lots of evidence that Justin Trudeau intentionally tried to get the Attorney General, pressured the Attorney General to stop the prosecution of SNC-Lavalin. And that's all that's needed to prove obstruction of justice. So if you can't stop a prosecution based on an incorrect legal standard saying we can't prove this.
The scandal led to Wilson Raybould resigning from cabinet and eventually being ousted from the Liberal Party. Conacher admits the issue may have long since faded from the public mind, but that doesn't mean it should be forgotten.
It was deliberately made old news by the RCMP, and it is a cover-up, and they tried to bury it, keep it secret, and just through delay, hope that everyone would stop paying attention and they would be able to, for completely unjustifiable reasons, let Justin Trudeau walk. And we're not going to give up on it.
Wilson Raybould won re-election as an independent in 2019, but left politics in 2021.
The RCMP had been doing its job and not covering up for him, then he would have been criminally charged. And again, he probably violated the criminal code in the SNC-Lavalin scandal. These would normally have led to criminal charges, but of course the RCMP covered it all up, and the leadership of the RCMP is frankly just despicable when it comes to enforcing laws against the Liberal government.
The podcast, I believe, was taped October 3rd, posted yesterday. He was referencing the RCMP's decision not to pursue criminal charges against Justin Trudeau or other people in the government over their involvement in the SNC scandal. Mr. Poilievre characterized the leadership of the RCMP as, quote, despicable when it comes to enforcing laws against the Liberal government and accused them of covering up for Trudeau. Do you have proof of that?
Well, as I just pointed out, there's direct evidence of an attempt by the Prime Minister, a sitting Liberal Prime Minister, to interfere with the Attorney General's carrying out of her duties. That audio was released. I listened to it on I believe you probably have too. That is what I would point to. That when the RCMP says, "Oh, there's no evidence of interference," it's like, well, sorry, what more do you need?
But I was not surprised. In fact, when Jody was kicked in the teeth by the Prime Minister and shuffled down to Veterans Affairs, as important as it is, that was a clear slap in the face for all Indians across the country.
These serious allegations lodged yesterday by Jody Wilson Raybould involve a lot of people not outside of just the Prime Minister. In fact, most of them are not household names. Here's a who's who of the key players.
An inappropriate effort to secure a deferred prosecution agreement with SNC-Lavalin.
The first name to surface in Wilson Raybould's testimony, Ben Chin, Chief of Staff to Finance Minister Bill Morneau. He allegedly reached out to Jessica Prince, Jody Wilson-Raybould's Chief of Staff.
He said to her, my chief, that if they don't get a DPA, they will leave Montreal.
Okay, the idea here is to get to the bottom of this scandal. Like, was Wilson Raybould being the honest lady, or did the Liberals do what they do and just lie and maul over another Canadian? Because that is what they've been doing, but we'll see.
Montreal, and it's the Quebec election right now, so we can't have that happen.
Wilson Raybould also says Morneau spoke to her directly and stressed the need to save jobs.
And I told him that engagements from his office to mine on SNC had to stop, that they were inappropriate.
I want to be clear. I never raised this issue with Jody Wilson-Raybould. She approached me in the House of Commons to inform me that my staff was speaking to her staff, which I think is entirely appropriate.
Then there is Mathieu Bouchard and Elder Marcus. Both are senior advisors to the Prime Minister. They allegedly pushed Prince and Wilson-Raybould more than once to seek outside legal opinion on negotiating a DPA.
Mathieu and Elder also raised the idea of a, quote, informal reach out, end quote, to the DPP. My chief of staff said that she knew I was not comfortable with that, as it looked like and probably did constitute political interference.
Then there's the Privy Council clerk, Michael Wernick. Between September and December, Wilson Raybould had 3 conversations with him, according to her, one involving the Prime Minister as well. In that meeting, they allegedly warn of SNC-Lavalin job losses and that there's an upcoming election in Quebec, and that the Prime Minister is an MP in Quebec.
I was quite taken aback. My response, and I vividly remember this as well, was to ask the Prime Minister a direct question while looking him in the eye. I asked, quote, "Are you politically interfering with my role, my decision as the Attorney General? I would strongly advise against it," end quote. The Prime Minister said, no, no, no.
Anyhow, this is all coming up. We're going to show the entire investigation in committee. Like right here, that is kind of what we do here at Canadian Looney. Like, we show the entire thing so you can make up your own mind. Let's get into that.
As we resume our meetings on the study of remediation agreements, the shock cost doctrine, and the discussions between the Office of the Attorney General and government colleagues as relates to SNC-Lavalin, I would very much like to thank our witness today, the Honourable Jody Wilson-Raybould, our colleague from Vancouver-Grenville, who has agreed to come before us today. As opposed to our standard practice of allotting witnesses 10 minutes, we all have agreed to afford Ms. Wilson-Raybould 30 minutes in order to be able to more fully tell her story. She is at the center of the events we're studying, and I think it's really important to give her that time. I would, of course, advise other witnesses that that will not be the normal practice of the committee. Before we begin Ms. Wilson-Raybould's testimony, Mr. Rankin has advised me he has a point that he wishes to raise, and I don't want her to eat into Ms. Wilson-Raybould's time. So I'll ask Mr. Rankin to give his point.
Thank you very much. There's actually 2 kind of related points. The first is that when she accepted our invitation, Ms. Wilson-Raybould wrote us, and I quote, "I will remain before the committee to answer questions for as long as the committee wishes." Now, you'll recall, Mr. Chair, that when we also extended time for Mr. Wernick, the clerk of the Privy Council office, and he was willing to stay longer as well. So I'd like to move that the committee accept her offer and allow her to spend longer with us either today or at some subsequent meeting. That's my first point. And the second was, since she's going to do a very lengthy statement in terms of how we've proceeded in the past, I'd like to ask if there is a written statement, if it could be distributed while she's speaking, because of course we will have even less time for questioning than usual as a result, and would give us, I think, more efficiency in asking questions if we had that statement before us in advance. Those are my 2 suggestions.
Thank you, Mr. Rankin. As to the first suggestion, I'm wondering if Ms. Wilson-Raybould does indeed have a statement that she would like to be distributed to the committee. Or would she prefer, because I think this is, I would like to go to her preference. What would she prefer?
I do have a statement. It's been provided to the translators, and if it is the will of the committee, they can distribute that to members.
So as soon as then copies are ready, Mr. Clerk, the committee agreed to have that statement in English only? Okay. We need. Mais on va le fournir dès que c'est possible.
We'll provide it as soon as possible, Mr. Fortin. We will provide it to you in French as soon as possible. You don't have it available right now. No, that's why I asked for unanimous consent from the committee to distribute it. And as I'm not a member of the committee, I can't vote. But I'd like to have a copy in English and a French one as soon as possible, as soon as it's ready.
So I think I have unanimous consent, so the clerk can distribute that. And as to the proposal, I very much appreciated Ms. Wilson-Raybould's offer to stay longer for questions. Our standard is 2 rounds. But I think there's agreement that we'll go longer than 2 rounds, and then let's take it round by round after round 3. We went for 3 with Mr. Wernick, then let's talk round by round if you have more questions.
Thank you, Chair.
Thank you very much. So would you like Mr. Rankin to get the statement before Ms. Wilson-Raybould begins, or can we begin?
That would be my preference if it could be made available.
How long will it be?
Well, at least 5-10 minutes.
It'll be 5 or 10 minutes. So I think it's only fair to the witness to let her begin. Ms. Wilson-Raybould, the floor is yours, and when we get to 30 minutes, I'll just give you a sort of sign to let you know that it's there.
House Father is almost a joke. Like, the way he looks, we won't pick on that too much. I'm not that handsome myself, but, like, this Anthony House Feather Father, whatever his name is a clown.
Okay.
Watch.
Thank you so much, Ms.
It's only going to
Wilson-Raybould.
get worse. All knows.
Well, Gaila Kusla, thank you, Mr. Chair, and thank you to the members of the Justice Committee for providing me the opportunity for extended testimony today. I very much appreciate it. And starting off, I would like to acknowledge the territory, the ancestral lands of the Algonquin people. For a period of approximately 4 months between September and December of 2018, I experienced a consistent and sustained effort by many people within the government to seek to politically interfere in the exercise of prosecutorial discretion in my role as the Attorney General of Canada in an inappropriate effort to secure a deferred prosecution agreement with SNC-Lavalin. These events involved 11 people, excluding myself and my political staff, from the Prime Minister's office, the Privy Council office, and the Office of the Minister of Finance. This included in-person conversations, telephone calls, emails, and text messages. There were approximately 10 phone calls and 10 meetings specifically about SNC, and I and/or my staff were a part of these meetings. Within these conversations, there were expressed statements regarding the necessity of interference in the SNC-Lavalin matter, the potential of consequences, and veiled threats if a DPA was not made available to SNC. These conversations culminated in December the 19th of 2018 with a conversation I had with the clerk of the Privy Council, a conversation that I will provide some significant detail on. A few weeks later, on January the 7th, 2019, I was informed by the Prime Minister that I was being shuffled out of the role of Minister of Justice and Attorney General of Canada. For most of these conversations, I made contemporaneous notes, detailed notes, in addition to my clear memory, which I am relying on today, among other documentation. My goal in my testimony is to outline the details of these communications for the committee and indeed all Canadians. However, before doing that, let me make a couple of comments. First, I want to thank Canadians for their patience since the February 7th story, which broke in the Globe and Mail. Thank you as well, specifically to those who have reached out to me across the country. I appreciate the messages, and I have read all of them. Secondly, on the role of the Attorney General. The Attorney General exercises prosecutorial discretion as provided for under the Director of Public Prosecutions Act. Generally, this authority is exercised by the Director of Public Prosecutions, but the Attorney General has authority to issue directives to the DPP on specific prosecutions or to take over prosecutions. It is well established that the Attorney General exercises prosecutorial discretion. She or he does so individually and independently. These are not Cabinet decisions. I will say that it is appropriate for Cabinet colleagues to draw to the Attorney General's attention what they see as important policy considerations that are relevant to decisions about how a prosecution will proceed. What is not appropriate is pressing the Attorney General on matters that she or he cannot take into account, such as partisan political considerations, continuing to urge the Attorney General to take her or his mind 4 months after the decision has been made, or suggesting that a collision with the Prime Minister on these matters should be avoided. With that said, the remainder of my testimony will be a detailed and factual delineation of approximately 10 phone calls, 10 in-person meetings, and emails and text messages that were part of an effort to politically interfere regarding the SNC matter for purposes of securing a deferred prosecution. The story begins on September the 4th, 2008. My chief and staff and I were overseas when I was sent a memorandum for the Attorney General pursuant to Section 13 of the Director of Public Prosecutions Act, which was entitled, quote, whether to issue an invitation to negotiate a remediation agreement to SNC-Lavalin, end quote, which was prepared by the Director of Public Prosecutions, Kathleen Roussel. The only parts of this note that I will disclose are as follows. Quote, the DPP is of the view that an invitation to negotiate will not be made in this case and that no announcement will be made by the PPSC, end quote. As with all Section 13 notices, the Director provides the information so that the Attorney General can take such course of action as they deem appropriate. In other words, the Director had made her decision to not negotiate a remediation agreement with SNC-Lavalin. I subsequently spoke to my minister's office staff about the decision, and I did the standard practice of undertaking further internal work and due diligence in relation to this note, a practice that I have had for many of the Section 13 notices that I received when I was the Attorney General. In other words, I immediately put in motion with my department and minister's office a careful consideration and study of the matter. 2 days later, on September the 6th, one of the first communications about the DPA was received from outside of my department. Ben Chin, Minister Morneau's chief of staff, emailed my chief of staff and they arranged to talk. He wanted to talk about SNC and what we could do, if anything, to address this. He said to her, my chief, that if they don't get a DPA, they will leave Montreal, and it's the Quebec election right now, so we can't have that happen. He said that they have a big meeting coming up on Tuesday and that this bad news may go public. This same day, my chief of staff exchanged some emails with my minister's office staff about this, who advised her that the Deputy Attorney General, Nathalie Drouin, was working on something and that my staff were drafting a memo about the role of the Attorney General vis-a-vis the PPSC. It was on or about this day that I requested a one-on-one meeting with the Prime Minister on another matter of urgency, and as soon as possible after I got back into the country. This request would ultimately become the meeting on September the 17th between myself and the Prime Minister that has widely been reported in the media. On September 7th, my Chief of Staff spoke by phone to my then Minister, or Deputy Minister, about the call she had received from Ben Chin, and the Deputy stated that the department is working on this. The Deputy gave my Chief a quick rundown of what she thought some options would be. On the same day, I received a note from my staff on the role of the Attorney General, a note that I also shared with that my office also shared with Elder Marquez and Amy Archer at the PMO. Same day, staff in my office met with the Deputy Minister. Some excerpts of the Section 13 note were read to the Deputy Minister, but the Deputy Minister did not want to be provided with a copy of the Section 13 note. September 8th. My deputy shared the draft note on the role of the Attorney General with my Chief of Staff, who subsequently shared it with me. And over the next day, clarity was sought by my staff with the deputy on aspects of the options that were laid out in her note. A follow-up conversation between Ben Chin and a member of my staff, François Giroux, occurred on September the 11th. Mr. Chin said that SNC had been informed that by the PPSC that it cannot enter into a DPA. And Ben again detailed the reasons why they were told that they were not getting a DPA. Mr. Chin also noted that SNC's legal counsel, Frank Iacobucci, and further detailed what the terms were that SNC was prepared to agree to, stating that they viewed this as part of a negotiation. To be clear, up to this point, I had not been directly contacted by the Prime Minister, officials in the Prime Minister's office, or the Privy Council office about this matter. With the exception of Mr. Chin's discussions, the focus of communications had been internal to the Department of Justice. This changes on September the 16th. My Chief of Staff had a phone call with Mathieu Bouchard and Elder Marquez from the Prime Minister's office. They wanted to discuss SNC. They told her that SNC had made further submissions to the Crown and that there is some softening, but not much. They said that they understood that the individual Crown prosecutor wants to negotiate an agreement, but the Director does not. They said that they understand that they're direct, but that they hear that our Deputy of Justice thinks we can get the PPSC to say, we think that we should get some outside advice on this. They said that they think we should be able to find a more reasonable resolution here. They told her that SNC's next board meeting is on Thursday, which was September the 20th. They also mentioned the Quebec election context. They asked my chief if someone has suggested the outside idea to the PPSC and asked whether or not we were open to this suggestion. They wanted to know if my deputy could do it. In response, my Chief of Staff stressed to them prosecutorial independence and potential concerns about the interference in the independence of the prosecutorial functions. Mr. Bouchard and Mr. Marquez kept telling her that they didn't want to cross any lines, but they asked my Chief of Staff to follow up with me directly on this matter. To be clear, I was fully aware of...
Sorry to interrupt everybody, but thank you, Ken. That's very much appreciated. My brother, Ken Flanders. Never convince them because you're on a res. You're not my brother. Like, I appreciate it. Thank you very much.
The conversations between September the 4th and 16th that I have outlined. I had been regularly briefed by my staff from the moment this first arose and had also reviewed all materials that had been produced. Further, my view had also formed at this point. Through the work of my department, my minister's office, and work I conducted on my own, that it was inappropriate for me to intervene in the decision of the Director of Public Prosecutions in this case and to pursue a deferred prosecution agreement. In the course of reaching this view, I discussed the matter on a number of occasions with my then deputy so that she was aware of my view, raised concerns on a number of occasions with my deputy minister about the appropriateness of communications we were receiving from outside the department, and also raised concerns about some of the options that she had been suggesting. On September 17th, the Deputy Minister said that Finance had told her that they wanted to make sure that Kathleen understands the impact if we do nothing in this case. Given the potential concerns raised by this conversation, I discussed this later with my deputy. This same day, September 17th, I have my one-on-one meeting with the Prime Minister that I requested a couple of weeks ago. When I walked in, the Clerk of the Privy Council was in attendance as well. While the meeting was not about the issue of SNC and DPAs, the Prime Minister raised the issue immediately. The Prime Minister asked me to help out, to find a solution here for SNC, citing that if there is no DPA, there would be many jobs lost and that SNC would move from Montreal. In response, I explained to him the law and what I have the ability to do and not do under the Director of Public Prosecutions Act around issuing directives or assuming conduct of prosecutions. I told him that I had done my due diligence and had made up my mind on SNC and that I was not going to interfere with the decision of the Director. In response, the Prime Minister reiterated his concerns. I then explained how this came about and that I had received a Section 13 note from the DPP earlier in September and that I had considered the matter very closely. I further stated that I was very clear on my role as the Attorney General and that I am not prepared to issue a directive in this case, that it would not be appropriate. The Prime Minister again cited the potential loss of jobs and SNC moving. Then, to my surprise, the clerk started to make the case for the need for a DPA. He said, quote, "There is a board meeting on Thursday, September the 20th, with stockholders," end quote. Quote again, "They will likely be moving to London if this happens, and there is an election in Quebec soon," end quote. At that point, the Prime Minister jumped in, stressing that there is an election in Quebec and that, quote, "I am an MP in Quebec, the member for Papineau," end quote. I was quite taken aback. My response, and I vividly remember this as well, was to ask the Prime Minister a direct question while looking him in the eye. I asked, quote, "Are you politically interfering with my role, my decision as the Attorney General? I would strongly advise against it," end quote. The Prime Minister said, no, we just need to find a solution. The clerk then said that he spoke to my deputy and she said that I could speak to the director. I responded by saying, no, I would not. That would be inappropriate. I further explained to the clerk and the Prime Minister that I had had a conversation with my deputy about options and what my position was on the matter. As a result, I agreed to and undertook to the Prime Minister that I would have a conversation with my deputy and the clerk, but that these conversations would not change my mind. I also said that my staff and my officials are not authorized to speak to the PPSC. And then we finally discussed the issue that I had asked for the meeting in the first place. I left the meeting and immediately debriefed with my staff about what was said with respect to SNC and DPAs. On September 19th, I met with the clerk as I had undertaken to the Prime Minister. The meeting was one-on-one in my office. The clerk brought up job losses and that this is not about the Quebec election or the Prime Minister being a Montreal MP. He said that he has not seen the Section 13 note. The clerk said that he understands that SNC is going back and forth with the DPP and that they want more information. He said that, quote, Yakabuchi is not a shrinking violet, end quote. He referenced the September 20th date and that they don't have anything from the DPP. He said that the Prime Minister is very concerned about the confines of my role as Attorney General and the Director of Public Prosecutions. He reported that the Prime Minister is very aware of my role as the Attorney General of Canada. I told the clerk again that I instructed my deputy is not to get in touch with the director, and that given my review of the matter, I would not speak to her directly regarding the DPA. I offered that if SNC were to I offered to the clerk if that SNC were to send me a letter expressing their concerns, their public interest argument, it would be permissible and I would appropriately forward it directly to the Director of Public Prosecutions. Later that day, my Chief of Staff had a phone call with Elder Marquez and Mathieu Bouchard from the Prime Minister's office. They wanted an update on what was going on regarding the DPAs since, quote, we don't have a ton of time, end quote. She relayed my summary of the meeting with the clerk and the Prime Minister. Mathieu and Elder also raised the idea of a, quote, informal reach out, end quote, to the DPP. My Chief of Staff said that she knew I was not comfortable with that, as it looked like and probably did constitute political interference. They asked whether that was true if it wasn't the Attorney General herself, but if it was her staff or the Deputy Minister. My Chief of Staff said yes, it would, and offered a call with me directly. They said that they will regroup and get back to you on that. Still on September the 19th, I spoke to Minister Morneau on this matter when we were in the House. He again stressed the need to save jobs, and I told him that engagements from his office to mine on SNC had to stop, that they were inappropriate. They did not stop. On September the 20th, my chief of staff had phone calls with Mr. Chin and Justin To, both members of the Minister of Finance's office, about DPAs and SNC. At this point, after September the 20th, there was an apparent pause in communicating with myself or my chief of staff on the SNC matter. We did not hear from anyone again until October the 18th, when Mathieu Bouchard called my chief of staff and asked that I look at the option of seeking an external legal opinion on the DPP's decision not to extend an invitation to negotiate a DPA. This would become a recurring theme for some time in messages from the PMO that an external review should be done of the DPP's decision. The next day as well, SNC filed a federal court application seeking to quash the DPP's decision to not enter into a remediation agreement with them. In my view, this necessarily put to rest any notion that I might speak to or intervene with the DPP or that external review could take place. The matter was now before the courts and a judge was being asked to look at the DPP's discretion. However, on October the 26th, 2018, when my chief of staff spoke to Mathieu Bouchard and communicated to him now that given that SNC has now filed in federal court seeking to review the DPP's decision, surely we had moved past the idea of the Attorney General intervening or getting an opinion on the same question. Mathieu replied that he was still interested in an external legal opinion idea. Could she not get an external legal opinion on whether the DPP had exercised their discretion properly? And then, on the application itself, the Attorney General could intervene, seek to stay the proceedings, given that she was awaiting a legal opinion. My chief of staff said that this would obviously be perceived as interference and her boss questioning the DPP's decision. Mathieu said that if 6 months from the election, SNC announces they're moving their headquarters out of Canada, that is bad. He said, quote, we can have the best policy in the world, but we need to get reelected, end quote. He said that everybody knows that this is the Attorney General's decision, but that he wants to make sure that all options are being canvassed. Mathieu said that if, at the end of the day, the Attorney General is not comfortable, that is fine. He just doesn't want any doors to be closed. Jessica, my chief of staff, said that I was always happy to speak to him should he wish. In mid-November, the PMO requested that I meet with Mathieu Bouchard and Elder Marquez to discuss the matter, which I did on November 22nd. This meeting was quite long. I would say about an hour and a half. I was irritated by having to have the meeting as I had already told the Prime Minister, etc., that a DPA on SNC was not going to happen, that I was not going to issue a directive. Mathieu in this meeting did most of the talking. He was trying to tell me that there were options and that I needed to find a solution. I took them through the DPP Act, Section 15, Section 10, and talked about the prosecutorial independence as a constitutional principle, and that they were interfering. I talked about the Section 13 note, which they said they had never received, but I reminded them that we sent it to them in September. Mathieu and Elder continued to plead their case, talking about if I'm not sure in my decision that we could hire an eminent person to advise me. They were kicking the tires. I said no. My mind had been made up and they needed to stop. This was enough. I will briefly pause at this moment to comment on my own state of mind. In my role as Attorney General, I had received the decision of the DPP in September, had reviewed the matter, made a decision on what was appropriate given a DPA, and communicated that to the Prime Minister. I had also taken additional steps that the Prime Minister asked me to, such as meeting with the clerk. In my view, the communications and efforts to change my mind on this matter should have stopped. Various officials also urged me to take partisan political considerations into account, which it was clearly improper for me to do so. We either have a system that is based on the rule of law, the independence of prosecutorial functions, and respect for those charged to use their discretion and powers in a particular way, or we do not. While in our system of government, policy-oriented discussion amongst people at early points in this conversation may be appropriate, the consistent and enduring efforts, even in the face of judicial proceedings on the same matter, and in the face of a clear decision of the Director of Public Prosecutions and the Attorney General to continue and even intensify such efforts, raises serious red flags in my view. Yet, this is what continued to happen. On December the 5th of 2018, I met with Jerry Butts. We had both sought out this meeting. I wanted to speak about a number of things, including bringing up SNC and the barrage of people hounding me and my staff. Towards the end of our meeting, which was in the Chateau Laurier, I raised how I needed everybody to stop talking to me about SNC, as I had made up my mind and the engagements were inappropriate. Jerry then took over the conversation and said how we need a solution on the SNC stuff. He said I needed to find a solution. I said no, and I referenced the preliminary inquiry and the judicial review. I said further that I gave the clerk the only appropriate solution that could have happened, and that was the letter idea that was not taken up. Jerry talked to me about how the statute was a statute passed by Harper and that he does not like the law. I said something like, that is the law that we have. On December the 7th, I received a letter from the Prime Minister dated December 6th, attaching a letter from the CEO of SNC Lavalin dated October the 15th. I responded to the Prime Minister's letter on December 6th, noting that the matter is before the court, so I cannot comment on it, and that the decision re a DPA was one for the DPP, which is independent of my office. This brings me to the final events in the chronology, the ones that signal, in my experience, the final escalation in efforts by the Prime Minister's office to interfere in this matter. On December 18th of 2018, my Chief of Staff was urgently summoned to a meeting with Jerry Butts and Katie Telford to discuss SNC. They wanted to know where I am at in terms of finding a solution. They told her that they felt like the issue was getting worse and that I was not doing anything. They referenced a possible call with the Prime Minister and the clerk the next day. I will now read to you a transcript of the most relevant sections of a text conversation between my Chief of Staff and I almost immediately after that meeting. Jessica. Basically, they want a solution, nothing new. They want external counsel retained to give you an opinion on whether you can review the DPP's decision here and whether you should in this case. I told them that would be interference. Jerry said, quote, Jess, there is no solution here that does not involve some interference, end quote. At least they are finally being honest about what they are asking you to do. Don't care about the PPSC's independence. Katie was like, quote, we don't want to debate legalities anymore, end quote. They keep being like, we aren't lawyers, but there has to be some solution here. Mojag, I text. So where were things left? Jessica, so unclear. I said I would of course let you know about the conversation, and they said that they were going to kick the tires with a few people on this tonight. The clerk was waiting outside when I left. But they said that they want to set up a call between you and the Prime Minister and the clerk tomorrow. I said that of course you'd be happy to speak to your boss. They seemed quite keen on the idea of you retaining an ex-Supreme Court of Canada judge to get advice on this. Katie Telford thinks it gives us cover in the business community and the legal community, and that it would allow the Prime Minister to say we were doing something. She was like, quote, if Jody is nervous, we would, of course, line up all kinds of people to write op-eds saying that what she is doing is proper, end quote. On December the 19th, 2018, I was asked to have a call with the clerk. It was a fairly lengthy call, and I took the call from home, and I was on my own, by myself. Given what occurred the previous day with my chief of staff, I was determined to end all interference and conversations about this matter once and for all. Here is part of what the clerk and I discussed. The clerk said he was calling about DPA's SNC. He said he wanted to pass on where the Prime Minister is at. He spoke about the company's board and the possibility of them selling out to someone else, moving their headquarters and job losses. He said that the Prime Minister wants to be able to say that he has tried everything he can within the legitimate toolbox. The clerk said that the Prime Minister is quite determined, quite firm, but he wants to know why the DPA route, which Parliament provided for, isn't being used. He said, quote, "I think he is going to find a way to get it done, one way or another. So he is in that kind of mood, and I wanted you to be aware of it." End quote. The clerk said he didn't know if the Prime Minister was planning on calling me directly or if he is thinking about getting somebody else to give him some advice. You know, he does not want to do anything outside of the box of what is legal or proper. He said that the Prime Minister wants to understand more, to give him advice on this or give you advice on this if you want to feel more comfortable you are not doing anything inappropriate or outside the frame. I told the clerk that I was 100% confident that I was doing nothing inappropriate. I again reiterated my confidence in where I am in my views on SNC and the DPA have not changed. I reiterate this is a constitutional principle of prosecutorial independence. I warned the clerk in this meeting that he was in this call that we were treading on dangerous ground here. I also issued a stern warning because as the Attorney General, I cannot act in a manner, and the prosecution cannot act in a manner that is not objective, that isn't independent. I cannot act in a partisan way, and I cannot be politically motivated. This all screams of that. The clerk wondered whether anyone could speak to the director about the context around this or get her to explain her reasonings. The clerk told me that he was going to have to report back to the Prime Minister before he leaves. He said again that the Prime Minister was in a pretty firm frame of mind about this, and that he was a bit worried. I asked what he's worried about. The clerk then made the comment about how it is not good for the Prime Minister and his Attorney General to be at loggerheads. I told the clerk that I was giving him my best advice and that if he did not accept that advice, then it is the Prime Minister's prerogative to do what he wants. But I am trying to protect the Prime Minister from political interference or perceived political interference or otherwise. The clerk acknowledged that, but said that the Prime Minister does not have the power to do what he wants. All the tools are in my hands, he said. I said that I was having thoughts of the Saturday night massacre, but that I was confident that I had given the Prime Minister my best advice to protect him and to protect the constitutional principle of prosecutorial independence. The clerk said that he was worried about a collision between the Prime Minister, because the Prime Minister is pretty firm about this. He told me that he had seen the Prime Minister a few hours ago and that this is really important to him. That is essentially where the conversation ended, and I did not hear from the Prime Minister the next day.
Well, I'm just letting everybody know that as chair, I choose to give you more than 30 minutes. You've exceeded it. I'd like you to be able to finish your statement. Is there anybody that has any objection to that? No. Okay, so please continue.
I don't think anyone in the audience does either.
Thank you, Mr. Chair. On January the 7th, I received a call from the Prime Minister and was informed I was being shuffled out of my role as Minister of Justice and Attorney General of Canada. I will not go into details of this call or subsequent communications about the shuffle, but I will say that I stated I believe the reason was because of the SNC matter. They denied this to be the case. On January the 11th, 2019, the Friday before the shuffle, my former deputy minister is called by the clerk and told that the shuffle is happening and that she will be getting a new minister. As part of this conversation, the clerk tells the deputy that one of the first conversations that the new minister will be expected to have with the Prime Minister will be on SNC Lavalin. In other words, that the new minister will need to be prepared to speak to the Prime Minister on this file. The deputy recounts this to my chief of staff, who tells me about the conversation. My narrative stops here. I must reiterate to the committee my concern outlined in the letter to the chair yesterday. That is, Order in Council number 2019-0105 addresses only my time as the Attorney General of Canada and therefore does nothing to release me from my restrictions that apply to communications while I proudly served as the Minister of Veterans Affairs. And in relation to my resignation from that post or my presentation to Cabinet after I resigned. This time period includes communications on topics that some members of the committee have explored with other witnesses and about which there have been public statements by others. The Order in Council leaves in place the various constraints, in particular Cabinet confidence, that there are on my ability to speak freely on matters that occurred after I left my post as Attorney General. Even with those constraints, I hope that through my narrative today, the committee and everyone across the country who's listening has a clear idea of what I experienced and what I know of who did what and what was communicated. I hope and expect the facts speak for themselves. I imagine Canadians now fully understand that, in my view, these events constituted pressure to intervene in a matter, and that this pressure, or political interference to intervene, was not appropriate. However, Canadians can judge this for themselves, as we now have the same frame of information. Lastly, as I've said previously, it has always been my view that the Attorney General of Canada must be nonpartisan, more transparent in the principles that are the basis of decisions, and in this respect, always willing to speak truth to power. In saying this, I was reflecting what I understood to be the vital importance of the rule of law and prosecutorial independence in our democracy. My understanding of this has been shaped by some lived experiences. I am, of course, a lawyer. I was a prosecutor in the downtown east side of Vancouver. So I come to this view as a trained professional and committed to certain values as key.
I am, of course, a lawyer. I'm a lawyer.
To our system of order. But my understanding of the rule of law has also been shaped by my experiences as an Indigenous person and as an Indigenous leader. The history of Crown-Indigenous relations in this country includes a history of the rule of law not being respected. Indeed, one of the main reasons for the urgent need for justice and reconciliation today is that in the history of our country, we have not always upheld foundational values such as the rule of law in relations to Indigenous peoples. And I have seen the negative impacts for freedom, equality, and a just society this can have firsthand. So when I pledged to serve Canadians as your Minister of Justice and Attorney General, I came to it with a deeply ingrained commitment to the rule of law and the importance of acting independently of partisan, political, and narrow interests in all matters. When we do not do that, I firmly believe and know we do worse as a society. I will conclude by saying this. I was taught to always be careful what you say because you cannot take it back. I was taught to always hold true to your core values and principles and to act with integrity. These are the teachings of my parents, my grandparents, and my community. I come from a long line of matriarchs, and I am a truth teller. in accordance with the laws and traditions of our big house. This is who I am, and this is who I always will be. Gala Kusla. Thank you.
Thank you very much, Ms. Wilson-Raybould, for sharing your perspective with the committee. It's much appreciated. So, folks, I'm just going to lay out the rules for the questions. I'm usually a very flexible chair in terms of time, but as we've done for the meetings on this issue, we're going to stick to the time limits. And as a result, I would ask if the witness where somebody's asking for a quick answer, it could be a little bit succinct. But I'll obviously want you to be able to finish your answers. So we're going to start. So the first round is 6 minutes Conservative, 6 Liberal.
Anthony Housefeather is one of the House Father, whatever, like, right? Housefeather father, is one of the biggest sellouts the Liberal Party has. Like, he's an embarrassment. He's easy to make fun of, but I'm not trying to pick on a low-hanging fruit, like, not literally, like, Anthony Hill, watch him. Just watch him go.
6 NDP, 6 Liberal, and I'll let everybody know in advance of every round what the time limits are. We'll start with Ms. Wright.
Thank you very much, Ms. Wilson-Raybould. I appreciate your patience on getting here today. It hasn't been an easy path, but I know that Canadians really appreciate it, and they appreciate your testimony today. And I just want to start off by saying that I believe every word that you said today. And I appreciate your honor, and I appreciate your honesty, and I appreciate your integrity and grit in coming forward in the way you have. So I do have some questions, though, and I'd be grateful for your input and your point of view. First and foremost, I'd like to know, the Prime Minister has said that you will be able to discuss all relevant information, but do you believe that there is relevant information that you are unable to include in your 30-minute statement that would be helpful for the committee?
Well, thank you for the comments and the question. As I said in my letter to the committee yesterday, as I said in my remarks today, the extent of the order in council and the waiver of privilege and confidentiality extends to January the 14th, when I was sworn in as the Minister of Veterans Affairs. So it does not include any conversations that occurred thereafter. It does not include conversations that I may or may not have had with the Prime Minister, and it does not include the conversation that I had with my former cabinet colleagues after my resignation from cabinet.
Do you think those would be relevant to our considerations?
Well, I believe that having heard some of the deliberations and questions asked by the committee over the course of the meetings that you've had, some of the questions would be answered if that information was made available.
One of the important pieces of your testimony today were the number of names that you provided for us, giving us a different list of characters that have been involved in this situation since it began in September. I'm wondering if you'd be so kind to provide us with a full list of those names. I've jotted down a few of them, but I don't have the complete listing. Would that be something you'd be willing to do for us?
I believe the full list of names is contained within the remarks that I think are being distributed, but if I counted incorrectly, I will provide all of the names.
I appreciate it. Just on page 14, you mentioned that there were various officials that came forward at the time. If you have any recollection of who the various officials were, that would be helpful for us in terms of making sure we have a complete list of all the witnesses. On January 7, you pointed out to us that you were told that you were being removed as the Attorney General. As well, you posted a very lengthy Facebook post after your movement to the Minister of Veterans Affairs, but I would assume that you thought a lot about what you would include in a note like this during the time when you were actually Attorney General. And as such, I think and I believe that the statement that you made, even though it was on when you were Minister of Veterans Affairs, technically did come to light and was part of your thought process when you were Attorney General. I just wanted to ask you a couple of questions about your Facebook post. The first one, and I quote, it's where, and you mentioned it in your remarks, it has always been my view that the Attorney General of Canada must be nonpartisan, more transparent, and in this respect, always willing to speak truth to power. Do you believe, for the record, that you were removed as the Attorney General because you spoke truth to power on the topic of the SNC ongoing prosecution?
Well, thank you for the question, and I am going to have to be very careful what I say.
I understand.
I believe that I am able to speak to my thought processes from January the 7th up to the time that I was sworn in as the Veterans Affairs Minister.
Yes.
I think it's apparent from my remarks that I was concerned that the reason why I was being shuffled out of the Minister of Justice and Attorney General possibly was because of a decision I would not take on SNC and the DPA. I raised those concerns with the Prime Minister and with Jerry Butts. And as I said in my remarks, those were denied. I cannot speak to anything that I thought about after that point.
I appreciate that. Second part of this letter, you say that the unique and independent aspects of the dual role of the Minister of Justice and the Attorney General of Canada are even more important. I know Canadians across the country expect such high standards to continue to be met, especially in the uncertain times in which we now live, and I expect this to continue. I'd like to know if you are concerned that it's possible that the independence of the Office of the Attorney General is being eroded now, given what you've told us in your testimony today, your understanding that the current Attorney General was to be briefed on the SNC-Lavalin deferment decision.
Well, thanks for the question, and I will not comment on the current Attorney General, but I will comment on when I was the Attorney General and the thoughts that I had when I was on vacation in Bali and when I received a call from the Prime Minister. While I was the Attorney General through these 4 months, leaving aside all of the very inappropriate political pressure, interference, I was confident in my role as the Attorney General that I was the final decision maker on whether or not a directive would be introduced on the SNC matter. So I knew as long as I was the Attorney General, this would not occur. I had concerns that when I was removed as the Attorney General, that this potentially might not be the case. I decided that I would embrace this new role, a very important role, and I really want to say publicly that the role of Veterans Affairs is an incredibly important role, and I took it very seriously. But I had decided to take on the role requested of me by the Prime Minister, but I had concerns, and I knew that in my new role, still sitting around the cabinet table, if there had been a directive that was placed into the Gazette, I would have resigned immediately from cabinet.
Thank you very
Well
much. Ms. O'Connell.
Thank you, Mr. Chair. Thank you for being here today and for providing your notes. I think they're helpful. My set of questions, I want to kind of get a general sense of some timelines. I know you've laid it out here, but just in trying to keep up a little bit. Would you say, or is it fair to say that in and around, and if I have the wrong date, please correct me, September 17th, I think is when you first met with the Prime Minister on where it wasn't the purpose of the meeting wasn't at first for the SNC-Lavalin, but it was brought up. And is it fair to say, was it at that point that you felt the questions of your role on this matter, that you were uncomfortable at that point? Or would you say you were uncomfortable from the initial feedback that you heard that your chief of staff had been contacted by Mr. Chin? So
let's specify exactly where in the 30 seconds you were made to feel uncomfortable. Like, oh my God. What was her name? Jennifer O'Connell? Lord.
So there's a couple of questions in there. If I don't answer them, please let me.
No problem.
So the reason for I requested the September 17th meeting, as I said, on an important matter. As I said, the Prime Minister brought up SNC and the deferred prosecution agreement. And with the clerk present, we had conversations about SNC. He brought up SNC about jobs and the potential of job loss. And I will say, entirely appropriate conversations for the Prime Minister to bring up. What I will say is that the conversations turned to be completely inappropriate when there was discussion about the Quebec election, about the fact that the Prime Minister was a member of Parliament in Quebec. It was at that point that I immediately became concerned, and because I was the Attorney General, sought to have a conversation with the Prime Minister about the law, about the role of the Attorney General and the necessary independence that the Attorney General must have in exercising their discretion, in this case around a prosecution. The political concerns that were raised prompted me to ask the question of the Prime Minister directly if he was politically interfering with my role as the Attorney General. So at that point, my senses were heightened. The Prime Minister assured me that that was not the case. But soon thereafter, I instructed my staff and myself as well to ensure that we had a very detailed chronology of all meetings and conversations about SNC and deferred prosecution agreements.
Thank you. So you wouldn't say that it was a red flag necessarily on the topic or the conversations with Mr. Chin on September 7th, because it was those conversations about businesses. It was once the conversation in your mind changed to any politics? Or were you equally concerned on September 7th?
On the earlier meetings prior to the meeting with the Prime Minister, Ben Chin had conversations with my Chief of Staff. And again, in terms of public policy, in terms of having discussions about impacts of decisions and loss of jobs, that was appropriate.
Okay.
But I will say, in those calls, and I don't have my notes in front of me, but I have a pretty generous memory, Mr. Chin raised the Quebec election, and I will say it's okay to talk about job losses. It's okay to talk about it in initial conversations, but when those topics continue to be brought up after there's a clear awareness that a decision has been made, it becomes inappropriate.
Thank you for clarifying. And sorry, I just want to clarify on that point because you mentioned
Thank you for clarifying.
And a pretty good memory. But in the written submission or your verbal remarks, any conversations, at least from September 7th, 8th, I think 11th, at least involving Mr. Chin, were with your staff, not you directly. Did you leave out conversations that you also had, or was it just notes that you had from your conversations with somebody who had a conversation with Mr. Chin? I just want to clarify.
Yeah, sure. No, I'm happy to answer the question if you'd permit me just to speak about how ministers, at least my minister's office works. Sure. I have an incredibly close relationship, necessarily so, with my Chief of Staff. I also at that time had a very close relationship with my Judicial Affairs Advisor, who throughout some of this period of time was acting as my Chief of Staff, given that we were out of the country. Whenever my Chief of Staff has a conversation, she takes notes on the conversation and immediately relays the conversation to me, particularly in cases where there's concerns about the conversations that were had. So the close relationship and the necessary closeness of the relationship makes it that she and I are sharing important information and proceeding on the same basis with respect to the meetings, telephone calls, and emails that she would receive. It is her obligation, and it was my instructions for her to provide me with all of these details.
Thank you. And
Ms. O'Connell, your last question.
Okay, perfect. Thanks. And then it was in here, I'm sorry, I don't recall, but it did say somewhere in these conversations that either you or your staff related on behalf of you that you would be, in this at least September timeframe, open to having further conversations on the SNC-Lavalin matter. Is that not correct? Or in September you had felt comfortable and confident that the decision was made?
Well, during that time frame, I had commenced conversations and had asked for briefings, as I regularly did when I received a Section 13 notice. I think it's fair for me to say that there was a heightened awareness about this Section 13 notice that came in with respect to SNC. These conversations were all internal to the Department of Justice, and I was exercising with my Attorney General hat on what was appropriate for me to consider based on what I read in the Section 13 note from the Director. We did not reach out externally. The Minister of Finance's office reached out to my department, and then these conversations began.
Thank you.
Thank you. Mr. Rankin.
Well, thank you. Mr. Chair, I have to say that I am very shaken by what I've heard here today. I've been a lawyer for over 40 years. I've taught a generation of law students about the rule of law. And what I've heard today should make all Canadians extremely upset. Now, Ms. Wilson-Raybould, we're both from British Columbia. We've known each other for many years, and I need you to know that I believe you entirely. I need you to know that. And I want you to know as well that I very much admire your courage in being here and telling Canadians what you have experienced. Because I believe, if we believe you, which I do, that there is no other conclusion that one can reasonably draw, but that there was a sustained, consistent effort to interfere politically with the critical role that an Attorney General must play in our legal system. You have said, to quote back what you said, I experienced a consistent and sustained effort by many people within the government to seek to politically interfere in the exercise of prosecutorial discretion in my role as the Attorney General of Canada in an inappropriate effort to secure a deferred prosecution agreement. You talked of 10 phone calls, 10 meetings specifically about that. And then you talked about what I would call the consequences and threats if you didn't knuckle under. You said the potential for consequences and veiled threat if a deferred prosecution was not available to the SNC were brought to your attention during those conversations. So my question is this: how can Canadians, if they believe you, as I do, draw any other conclusion but that there was an attempt to politically interfere with your role as our independent Attorney General?
Well, thank you for the comments and the question, albeit I think the question is somewhat rhetorical. I sought in my testimony today to state facts. And in my testimony, I came to the conclusion, and throughout the 4 months, that there was a sustained effort, an attempt to politically interfere with my discretion as the Attorney General of Canada. It was inappropriate.
And on January the 11th, you said that the Friday before the cabinet shuffle, your former deputy minister was called by the clerk and told that the shuffle was happening, and that the deputy minister said one of the first conversations that the new minister will be expected to have with the prime minister would be on SNC-Lavalin. So it appears to a reasonable person looking at that you were removed from your role because you would not change your mind, despite these persistent and consistent efforts to have you do so, and that because you didn't change your mind, you were fired from the role of Attorney General. That's what I take from the material. In other words, there appears to be a direct link from that conversation the day before the cabinet shuffle and what occurred, your removal from your role as Attorney General. That would appear to be what's said. Now, I have a question. After this what you call consistent and sustained pressure to reverse your decision, I'd like you to tell us a little bit more why you did not change your mind.
I did not change my mind to enter into or to issue a directive to the Director of Public Prosecutions on the matter of putting out an invitation to negotiate a remediation agreement with SNC, because I had the benefit of reading the Section 13 note, of conducting my own due diligence around the appropriateness of entering into a deferred prosecution agreement with SNC. I had the benefit of feedback and briefings from my departmental officials as well as my political staff. I made my mind up prior to the September 17th meeting. And for those people that know me, my decision-making process takes into account many views, and I welcome many views on public policy issues. And having taken into account many diverse views, knowing confidently my role, my independent role as the Attorney General, and the need to make a decision, and I know you are studying the Shawcross principles, and I don't want to get into talking about the Shawcross principles, but as the Attorney General, you make decisions with your judicial hat on, leaving aside political considerations or otherwise. I had determined that I was not going to issue a directive. It was inappropriate to interfere with the discretion of the Director of Public Prosecutions, and having made up my mind, taking into account all of the information, again, for those who know me, I was not going to change my mind.
Thank you.
Thank you very much. Ms. O'Connell?
Thank you. Thank you. So following up on some of those timeline questions, I just want to, it looks like in the response you didn't meet again with Jerry until December 5th in terms of raising your specific concerns that you felt this was interference. So just given that how long you've known Mr. Butts, and I believe it's been widely reported he was someone who recruited you, so you had known each other even prior to politics to run for the Liberal Party. I'm just curious if it is fair to say that it wasn't until the December 5th meeting with Jerry, Mr. Butts, that you hadn't messaged him about your concerns about what you described as constant pressure. If you had communicated with him in any way via text, email, whatnot, prior to that December 5th meeting to say that you felt these conversations needed to stop?
Well, I'm not going to comment on the nature of my relationship with Mr. Butts.
That's fine.
But I will say that
come on,
it was the Prime Minister, the then leader, that recruited me into the party, and of course there were ongoing conversations between him and Mr. Butts.
Sorry, can I just say then, is it fair to suggest though that you had known him and you were comfortable with him, you had talked to him, I would assume, regularly?
Yeah, of course.
Okay.
I had.
I would agree that I should grow up, but I refuse to. Like Mr. Butts, it always triggers my laugh reflex.
I had fairly regular conversations with Jerry. In fact, Jerry said to me many times, and I don't think this is a secret, that I talk to you more than I talk to most ministers. And I appreciated that relationship. To the second part of your question, as I said, there was sustained efforts at communications, not only with myself, but with my office, from various members of the Prime Minister's office, including Mathieu Bouchard and Elder Marquez, both of whom are policy advisors and legal advisors to the Prime Minister, as well as to Jerry Butts and Katie Telford. It would have been, in my view, not a secret that these were concerns that I had.
But if it just following up on that, if it wasn't a secret that those were your concerns, why not until December 5th did you communicate with Mr. Butts specifically about those communications? It was somewhat stated that you would be willing to, or someone in your office would look at the matter back in September. So if it was constant, and you acknowledge that you spoke to Mr. Butts on a regular basis, why not raise it earlier in September or October about those ongoing conversations with anyone in the PMO or other ministers' offices? Or did you, I guess is a fair point, did you communicate prior to that about those concerns?
I appreciate the question and being able to clarify again the timeline. I absolutely communicated in September, not to Jerry Butts, but to the Prime Minister of the country, the concern that I had. I communicated to the clerk of the Privy Council, who, as everybody knows, is the Deputy Minister to the Prime Minister. I communicated to Elder Marquez and to Mathieu Bouchard. I communicated to the Deputy Minister of Justice and the Deputy Attorney General of Canada. And when the sustained efforts of political interference continued, I felt, and I have text messages when I requested the meeting with Jerry, that ultimately resulted on December the 5th, that it was time to reiterate my concerns to him about the inappropriate nature of these conversations, as I did to Minister Morneau in October, I believe, or September, I might be getting the dates wrong, about the inappropriateness and that they had to stop.
So then you didn't mention Ms. Telford. So is it fair to say you didn't speak with Ms. Telford, I guess, between those September dates? Or did you ever mention it to Ms. Telford about or have communications via text, emails, and writings that what you say were continued pressure?
Just to correct, it was September the 19th that I had the discussion with Minister Morneau. To your question, most of the conversations that I have with the Prime Minister's office at the highest level, either Katie or Jerry, would be with Jerry Butts.
Okay.
But to be clear, my Chief of Staff had direct conversations with Mr. Butts and Ms. Telford, as I described in detail on December the 18th.
So early, and then after September 19th, that meeting with the Prime Minister, did you speak to him again about the continued pressure that you felt?
The meeting I had with the Prime Minister was on September the 17th. And after September the 17th, I did not directly talk to the Prime Minister until January the 7th. But in between those dates, there were, as I described, numerous meetings with the Prime Minister's office senior staff, as well as the clerk of the Privy Council.
And you mentioned earlier in my first round that you felt it was entirely appropriate to have the conversation about the jobs and those types of impacts. I'm paraphrasing here, and then you mentioned Minister Morneau and the conversation you referred to on the 19th, which was in the House, I believe you said in the testimony, and you said that he mentioned job losses. So what made you feel that conversation was then inappropriate?
Was inappropriate?
Yes.
So to the first point about mentioning jobs and job losses, as I said in my evidence, including the conversation I had with the Prime Minister, I do not believe it is inappropriate to have conversations about job losses, about SNC in the early stages where ministers can raise these issues with the Attorney General. What is inappropriate is the long sustained discussions about the job losses after it is very clear that I had made my decision and was not going to pursue a DPA. But leaving aside job losses, the conversations that I had where they became very clearly inappropriate was when political issues came up, like the election in Quebec, like losing the election if SNC were to move their headquarters. Conversations like that, conversations like the one I had with the clerk of the Privy Council, who invoked the Prime Minister's name throughout the entirety of the conversation, spoke to me about the Prime Minister being dug in, spoke to me about his concerns as to what would happen. In my mind, those were veiled threats, and I took them as such. That is entirely inappropriate.
Thank you very much. So now we move to the second round. In the second round, it goes 6 minutes to the Liberals, 6 to the Conservatives, 6 to the Liberals, 5 to the Conservatives, 3 to the NDP. So that is round 2. We'll start round 2 with Ms. Sahota.
Thank you, Mr. Chair. So I'd like to first go back to the September 17th meeting with the Prime Minister and the Clerk of the Privy Council. You mentioned that it was here where you had specifically asked the Prime Minister whether he was interfering, and his answer was that the decision was always yours. Is that correct?
That's not exactly what I said. I had raised the background about comments that were made by the Prime Minister and the clerk, and I know that has been what has been reported in the media, but that's not what was said. I asked the Prime Minister a direct question after having comments around elections and being the member of Papineau. Are you interfering with my role as the Attorney General, my decision? And I advised him strongly not to do that. So it was my direct question to the Prime Minister.
And he said the decision was always yours, correct?
He did not say that. He said, no. That's not what I'm doing.
Okay. But you did mention in your opening statement that throughout the whole time you were Attorney General, you did recognize that the decision was always yours.
I 100% understand my role as the Attorney General, and it is my decision and my decision alone whether or not to issue a directive.
Okay. So this September 17th meeting, you had asked for it earlier in September, and you said at that point you had gone on vacation. And did you receive this request for the meeting quite quickly?
I didn't say that I went on vacation. I was actually down in Australia for a Five Eyes meeting and happened to thankfully have a couple of days off. When another very important issue arose. And I, at that point, had requested directly to Jerry Butts via text message that I wanted to have a one-on-one meeting with the Prime Minister. That was in and around September the 6th.
Okay. And then on September 17th, you received the meeting after you came back into the country.
I got back into the country on September the 12th and was able to meet with the Prime Minister, yes, on September the 17th.
Okay. So the main purpose for this meeting, what was the main purpose of the meeting?
I am not at liberty to discuss that as meetings and discussions between the Prime Minister and myself, other than what's covered in the waiver with respect to SNC and deferred prosecution agreements is covered by Cabinet confidence.
When the Clerk of the Privy Council testified here before committee, he had mentioned that the main purpose of that meeting was the Indigenous rights framework and that SNC-Lavalin was a subject matter that was touched on briefly. Would you be able to say if that was correct or incorrect?
I will say that the Clerk of the Privy Council is at liberty to say whatever he wants. I have indicated that the meeting of September the 17th had to do with another extremely important matter, but that the Prime Minister raised the issue of SNC and deferred prosecution agreements at the outset of that meeting.
Okay. My next question is about the fact that you had mentioned the appropriateness or inappropriateness and where the line has kind of been drawn. You've indicated that when talking about jobs, the Prime Minister or the member from Papineau was completely in an appropriate space. But when you said he had spoken about the headquarters moving out of Montreal, that was inappropriate. Is that correct?
No, I didn't say that. I said that where, and I didn't say alarm bells, but where my alarm bells went off was when the clerk of the Privy Council talked about the fact that there was a board meeting for SNC coming up on Thursday, September the 20th, that there was an election in Quebec, and then the Prime Minister interjected and said, I'm a member, or I'm an MP from Quebec, the member for Papineau. That is entirely political and entirely inappropriate, which gave rise to the question that I asked the Prime Minister.
You had mentioned, just in some of your answers to the questions, about him mentioning he's the member from Papineau, correct, that he was talking about the election, and then he had mentioned that if we don't find a solution, the company might move from Montreal. And I mean, in my view, when a company picks up and moves from a city or from a country, that means job losses. Is that not correct?
Well, that's your view. Of course, I was aware of the potential for job losses.
Okay. And that is a legitimate conversation for a Prime Minister to have.
Well, again, at the time, I didn't see it as being entirely inappropriate. Of course, ministers of the Crown can approach the Attorney General and raise public policy concerns about decisions that the Attorney General will make. Where it became inappropriate was the sustained discussions after I had made my decision and made my decision known.
On September 18th, I believe you.
This will be your last question.
Okay, thank you. On September 19th, you had both met with the clerk and you had met with Minister Morneau in the House. In your discussion with Minister Morneau, I believe you had said that it's inappropriate and he should stop talking about it when he had talked about saving jobs. But in your discussion with the clerk on that same day, you had offered that if SNC-Lavalin were to send a letter to you expressing their concerns and their public interest arguments, you were open to looking at that letter. Is that correct?
That's not correct. I did.
It's here in your statement, opening statement.
If you allow me to answer, I can just clarify where that part wasn't correct. I had discussion with the clerk of the Privy Council, recognizing the conversation that I had just the day before had with the Prime Minister, where he asked for solutions, recognizing I had already made my decision. I had indicated to the clerk of the Privy Council that if SNC were to send a letter to me as the Attorney General expressing their concerns, their national interest concerns, their public interest concerns, that if I were to have received a letter, I would have immediately forwarded it on to the Director of Public Prosecutions. I would not have looked at it because it is entirely within the purview of the Director of Public Prosecutions, and any involvement I would have in that letter would be inappropriate. So what I said was I would immediately forward it on to the Director, not consider the letter.
Okay, thank you.
Thank you. Ms. Raitt.
Thank you very much. Ms. Wilson-Raybould, when you speak to Jerry Butts or Katie Telford or the clerk of the Privy Council, do you believe that they are speaking with the full authority of the Prime Minister in their discussions with you?
Yes.
I'm wondering some specific questions, if I may. Do you believe that the Prime Minister or anyone in the Prime Minister's office had any lawful authority to tell you to direct the Director of Public Prosecution on what to do?
No, I was the final, and as the Attorney General, is the final decision maker on whether or not, as the top prosecutor, to do anything with respect to a specific prosecution.
Yeah. Is it fair to say that, given your testimony and everything you've told us, that you suffered from repeated communications with you, either directly or indirectly, with the intent of changing your mind? It was repeated communications, directly or indirectly.
That's fair to say.
Okay. I'm wondering as well, given the number of times in the final part of your statement Mr. Butts indicated to you in your conversation that
Mr.
you needed
Butts.
to find a solution to the issue. The clerk of the Privy Council, in the statement that you received, in the text that you received from your chief of staff, there's details about not wanting to debate legalities anymore. There's no solution that doesn't come from some interference. The clerk indicating that I think the he, meaning the Prime Minister, is going to find a way to get it done one way or the other. You reference as well that it's the Prime Minister's prerogative to do what he wants. You said you were having thoughts of the Saturday Night Massacre. The clerk said he was worried about a collision between you and the Prime Minister. You mentioned a few minutes ago that you thought they were veiled threats. This all seems to me, if I may, that there was an intention from all of these comments and this continued pressure to make you fear for your job at the end of the day, that there would be a shuffle or that you would be removed from your position. Is that a fair assumption that I'm making?
Well, I'm not going to speak to the intention of other individuals.
Fair enough.
I will speak to the very heightened level of anxiety that I had that increased and culminated in my discussion with the clerk on December the 19th. And I remember distinctly ending that conversation with the clerk by saying, I am waiting for the other shoe to drop, which I believe that reflection or my comments can speak for themselves.
And I'm not trying to split a hair here, and I apologize if you take it that way and you can give me the same answer as you did on intention. But do you think the purpose of those comments were to cause you to have a second look at the issue because you were worried about whether or not you'd remain in cabinet?
Can you answer the question again?
I certainly can. Do you think the purpose of those comments that were thrown into your conversations, either with you, with your chief of staff, directly with the clerk, through Jerry Butts, through Katie Telford, or even the clerk indicating how anxious the Prime Minister was and you didn't want to be at loggerheads, do you think the purpose of those comments that they threw in their conversations was to put pressure on you and make you think about whether or not you would be remaining in cabinet?
I am confident that the purpose of those discussions, the December 18th and the December 19th discussions, were to put extraordinary pressure on me to change my mind.
Yeah.
As to the intention of the individuals that spoke to either my chief of staff or myself, I can't reflect on their intent.
Yeah, no, fair enough. Okay. If I may, on January 7, you received your phone call that you were going to be moved in positions. I've had that phone call in the past as well, so I know what it's like. But I'm wondering if there was any conversation that you can tell us about in terms of who told you that you were going to be moved from Attorney General to Veterans Affairs, and if there's anything pertinent to SNC in that conversation.
Well, I did state, and this is within the order in council and the waiver that was provided me with respect to cabinet confidence, with respect to SNC and deferred prosecution agreements. I had a conversation with the Prime Minister on January the 7th, and he spoke to me about my being shuffled out as Minister of Justice and Attorney General, provided rationale of which I won't get into. And then I said to him, I can't help but think that this has something to do with a decision I would not take. I had a subsequent, very close in time conversation with Jerry Butts where I specifically said, I know this has to do with SNC and a decision that I wouldn't take. To which he said, are you questioning the integrity of the Prime Minister? To which I didn't say anything.
Thank you.
Thank you very much. We will now go to Mr. Sassi.
Thank you, Mr. Chair. Thank you, Ms. Wilson-Raybould. Good to see you here before committee today. Now, I won't be delving into facts. I will be talking about context, if you will. Now, you recall that in your capacity as Minister of Justice and Attorney General, that remediation agreements were considered and approved by Cabinet. Is that correct?
That is correct.
And you were also a Minister of Justice and Attorney General on June 6th when Parliament voted in favor of Bill C-74, and you yourself voted in favor of Bill C-74. Thank you. Now, you would agree with me that the concept of alternatives to prosecution is not a novel concept in the landscape of various areas of law. For example, in the area of international law, there are guidelines, going back to the 1990s about alternatives to prosecution. We see this quite often when it comes to our own criminal code, when it comes to diverting cases through the Youth Criminal Justice Act. We see it with respect to white-collar crime. Would you agree that it's that this concept has been around for quite some time?
I will say this. We now have in our criminal code tools that are provided to the prosecutors on whether or not to enter into negotiations around deferred prosecution agreements. These are tools that other countries have utilized.
Speaking of other countries, as you noted, and you did reference the Five Eyes, to the best of my understanding, with the exception of New Zealand, the United States has had deferred prosecutions. The United Kingdom has had it. France has a DPA-like mechanism. Australia is in the process of adopting it. So given all these developments, would it be fair to say that many commentators are of the view that we are now leveling the playing field and that we are playing catch-up with those jurisdictions?
Well, I'm not going to comment on what other commentators are saying, and I will say this. I am not going to make further comments on deferred prosecution agreements. I recognize my responsibilities as a member of Parliament, and I recognize that there are two court cases that are currently in play.
So perhaps I understand you don't want to speak to that issue, but you would agree that there were extensive public consultations on the issue.
There were consultations that were conducted in advance of the passage of the legislation.
Yes. Now, I understand in your remarks, you were suggesting that some people were approaching you and asking that you obtain legal counsel. Would it be fair to say, as a routine matter of work, that your department does receive legal advice from various firms?
I'm sorry, could you clarify what
Yes.
you meant by people were approaching me to obtain legal counsel in what context?
Yes, I understand that you referred that there was one discussion with Mr. Bouchard, and he asked you whether you would consider the option of seeking an external legal opinion.
So in the context of deferred prosecution agreements and SNC, yes, I had that conversation with Mathieu Bouchard, Elder Marquez, and a number of other individuals. At that time, all of those individuals knew that I was firm on my decision not to interfere with the discretion of the Director of Public Prosecutions, and having conversations about hiring external legal counsels in that environment is entirely inappropriate.
But you've worked on some very difficult files during the period you were serving as Minister of Justice and Attorney General. Would it be fair to say that routinely you would ask for outside counsel just to have a better understanding of various pieces of legislation?
In my role as the Minister of Justice, and having had the opportunity, as people here know, coming before this committee on various pieces of legislation, we would engage with external counsel. But let me be clear. My role as the Minister of Justice, shepherding legislation through the House of Commons, is entirely separate from my role as the Attorney General. Where suggestions of obtaining external legal counsel after I had made my decision as the Attorney General on this matter, that was entirely inappropriate.
Thank you very much. Last question, Mr. Assassi.
Thank you. Now, before I leave this section, would you mind explaining to us what your misgivings were about DPAs?
I do mind. I'm not going to have that conversation. I think it's inappropriate as a member of Parliament, recognizing that there are two matters before the court.
Thank you very much. Monsieur Paulus?
Merci.
Mr. Paulus, thank you. Thank you, Ms. Wilson-Raybould, for this very important testimony for Canada and for democracy. Before I begin, I just wanted to give Ms. Raitt a few moments.
Ms. Wilson-Raybould, first of all, having heard it all, I have to ask you the question. Going from being your first appointment and going through the last 4 months, and although having comfort going into Veterans Affairs, which is a wonderful portfolio, and I agree with you fully that you served there. How did you feel at the end of this? Like, what's the emotion that you felt out of all of it? I mean, you're giving us wonderful facts, but surely there must be some level of disappointment or sadness out of how everything has unfurled.
Generally, or with respect to being moved as minister?
No, in general, how you've been treated.
Try to keep it from screwing up too many times. So right there, I screwed up and hit a funny button, or not a funny button, but just a button. We're going to wrap it up right there. This has been a very successful show. My name's Aaron. This is Canadian Looney. We show the politics. A lot of people just want to show all the new stuff. And I do too. I know that's a big piece of the trying to grow. I am trying to grow this channel. I'm at a very difficult time in my life. It's hard to explain. Okay, well, these are the facts. My old man committed the S word. He jumped off a bridge. He was my best buddy. I talked to him every day. I talked to him on the morning that it happened. And he wasn't feeling good. So he went to the hospital to let them know. And again, my dad wasn't some bum. He was a elementary school principal for 30 years. He was municipal councilor for years after that. He was hockey coach and a good person. Again, I didn't like him very much in my teenage years, but in my 20s, I realized what a wonderful person this man is. And after his death, the messages and the support that came in, friends of mine that I wouldn't even know. They wouldn't confess it to me, but they would confess it just openly after that happened. He was their father figure, I guess. And I can understand what that would be. He was an amazing person. His name was Miles, and he was an amazing guy. I'm not going to get myself all wound up here, but it crushes me every time people start talking about that they have it heavy or whatever. your dad who failed through COVID. That didn't help. Like the whole pandemic, whatever that shutdown was, maybe it was the shots. Maybe it was because he had a couple of health issues that deteriorated very quickly after he got the shots. And like, I got a couple of shots. It didn't affect me that I know about yet, but all I know is that he was sick one day, like really sick, and he told me in the morning he wasn't feeling good. Like, he's like, I think I've lost my place in this world. And I'm like, that's a bad feeling, because I can relate to that feeling, like not knowing what your place is in this world. Nevertheless, he drove up to the hospital. He called my mom back a couple hours later. He's like, and he was excited. She said she could hear it in his voice that he was excited that he was going to get help. And then I guess the computer or whatever, the algorithm AI interface, whatever, at just a simple program said, nope, just go home, take these pills. Instead, he drove to a bridge, then it was over. And I'm probably not going to get over that. Like, I'm not individually angry at anybody for that. Like, there's no particular person. Like, I don't blame anybody. Like, would I blame the programmer that got paid to make that program? Probably not. That wouldn't be fair. But also, I don't think the repercussion is fair. Like, and I've done a lot of really good things since then. Like, I had a brutal career with the liquor distributor here in Nova Scotia, and it was a brutal time. Like, the first year or two you get in, you think like, oh, I'm set for life. Like, I've got a really easy government job. And the work is easy. There's no doubt about that. But if you're a worker and like if you're a worker bee, like if you're looking to improve things, and anyways, I was there for 18 years. It didn't kill me. They tried. And don't ever let them tell you that Dr. Traeger and all of their board of directors didn't try to kill me. Because, well, we're in the courts now. We'll see how that goes. Like, I'm as confident as I can be because I recorded them for 5 years. Every conversation, everywhere as I went, I had it recorded. And they're going to try to say that that's not legal. I knew what they were doing, which was trying to screw me, and they were doing it illegally. Like, I was always a good worker. I was. Like, and not stupid either. Like, professional logistician, I used to do customs imports for them, and I know a lot of imports that they should have not imported that I put through. And I'm willing to, anyways, that company has, well, they feel they have the right to try to fight me in court. They should just back down and leave it all alone. I'm not looking for anything more than what I'm due, and I'm due a couple of years from y'all. Anyway, that has nothing to do with the channel that we do here. I started doing this channel thinking like, oh, well, maybe there's an option. And I only wanted to make a YouTube channel, like to see if I could make a YouTube channel. But then I started making a channel about Canadian federal politics. and I got really sucked in. It sucked me in at the same time as I was like wondering why my standard of living was going downhill at the same time as like in the same timeline as like the amount of time that I've had at the NSLC, because my standard of living should at least keep up. But then I watched Sunshine Baby for an episode. I watched him the second day. I was like, oh, that's pretty interesting. Like just the House of Commons question period stuff. Then I sent him a message and I'm like, I'm going to do what you're doing, but I'm not going to bum money. I hope that doesn't offend you. And here we are 2 years later. So that's pretty much it. Like, I think Sunshine Baby does a good job. There's other people that do a much better job. Moose and the Loose, not going to lie, man. Who doesn't love watching that guy's episodes of anything? He makes everything interesting. Who else? Like, Elevate is pretty good. There's a Canadian taxpayers guy, like a younger fella. He's really geeky and whatever, but he's sharp and he's articulate. Anyways, we're just going to go. I got myself put into a different spot when I started thinking about my dad, because that one still crushes me. It still crushes me. And since that happened, I bought the house that I grew up in, like, boom, bought it with cash, and, well, left me pretty broke, but my poor mom is very sick now. And I've been ostracized by this community because of my father's death. Like, it makes everybody so uncomfortable. They don't know how to talk to you or think that they can't. Like, I don't blame any particular person for the way it went down that day, because, like, again, I was talking to him in the morning and he told me I'm not good. And I was like, well, go for your walk, do your whatever. He's like, I think I'm going to go to the hospital. So he went to the hospital, and the thing about those machines or whatever, like programs where they're asking you, how do you feel about your mental health? People are always going to like kind of bend the truth, or at least that generation will. They're always going to say, I'm feeling a bit better. It's not that bad or whatever. Again, my old man went to the hospital and told them like he was not feeling right. And they said, okay, well, let's just put you through the process. And he did the process, which would be like, yes or no, how do you feel? That kind of shit on a keyboard. And then they told him, like, no, we're not going to be able to help you. Like, between that time and the time before, he was very hopeful. He was like, oh, they're going to send me somewhere. And again, I don't believe in those people making you better. I've been through that. They don't make you better. But they shut out his window of hope. And now I've got a really very ill mom. Like, could be any moment, could be now, could have been 5 minutes ago, could be 10 minutes from now. And whatever. We try to keep it light here most of the time. It's been a long show. If you've hung around to this point, then, well, sorry for that. But we're just trying to work through it, because, like, it does end at some point. Anyways, back onto the topic. Jody Wilson Raybould got screwed over. It would look like, it would seem to me that She definitely tried to take the high road, and the Liberal Party, Prime Minister Trudeau, shot her down from up there and then tried to cover up the conspiracy. Is that going to be the one that brings down this government? Is that going to bring it more into the headlines? Because, like, CBC, CTV, the hack media, Global, all the newspapers, radio stations that just allow them to accept ads from Liberal parties, donors, and push some bullshit Liberal propaganda. Because around here, people call everybody on the East like stupid. That's not it. But if they only read the newspapers and only listen to the local radio, which for a million years in Canada you could have trusted, for about 100 years, really, at least, you can't trust that anymore. The local channel here is talking about elbows up still, like on their banner or whatever, like their radio banner. They talk about elbows up and Canada free and just liberal bullshit propaganda. And we're kind of tired of that around here. I am. Like, and I'm not a conservative. Like, don't get that wrong. I'm a voter. Like, I see that I do have a closer eye on it than most people do, so it's not as separate as like liberal, conservative as it used to be. But like hanging on to one side or the other or any party in general is just foolery. Like, to me. Anyhow, we're wrapping up, guys. That's it. Thank you all so much for watching. Aaron, Kennedy, and Lodine. We're out.